Good morning. Welcome, everyone. We are getting ready to start the webinar in just a moment and waiting for folks to join with us. So we'll give it just a minute. And if you're joining us today, we want to make this session a little bit more like a conversation instead of a webinar. And so Marjorie Schultz has encouraged us all to turn on our cameras if we're comfortable and have a conversation, ask questions as we go along. So if you're comfortable with turning on your camera, you'll see that you can do that, or if you'd like to join with audio only, you can do that as well. I'm going to wait right now. It looks like it's the three of us that are on the call, and so I'm going to give it just a little bit of time before we begin.
Okay.
My clock just says 11:31, so. So in the interest of time, I think we'll go ahead and get started. And Marjorie, we're going to go ahead and record this session of your presentation so people can watch it at a later time. And then if we have questions, we have folks that want to ask questions, we can entertain those at the end of your session.
That'd be fine.
Okay, good morning and welcome everyone to our final session of our webinar series, Smart Planning for Smart Women. I'm April Hampton Perez, class of 1989 and Senior Director of Development at Southwestern. We're so glad you could join us this morning for this informative session on modern families. Again, you're welcome to turn on your camera at any point and engage in questions. Or you can save your questions to the end of the session, whatever you're most comfortable with. Today, I'd like to introduce our speaker, Marjorie Schultz. Marjorie graduated from Southwestern in 1970, and after leaving Southwestern, she received her law degree from Duke Law School. She is well recognized for her work in estate planning with special emphasis in the area of charitable giving, and has lectured extensively at national and state forums. She is also board certified in estate planning and probate law by the Texas Board of Legal Specialization. Marjorie has her own practice in Houston, and her grandson is a current SU student. Please welcome Marjorie Schultz.
Thank you, April. I am getting something saying my internet connection is unstable now, so who knows? Give me a signal if you're having trouble seeing or hearing. This morning, the topic is modern families, planning for modern families. When I think about modern families, I think about those contrasted with the traditional family being man, wife, and children, which is what used to be traditional, I suppose. But these days, we have lots of families that don't fit that traditional family mold. We have families where the parents have been married to other partners or have other partners and have children by other relationships. And so those I think of as modern families, although they're, they're even as prevalent as traditional families these days, estate planning. Then, of course, we have couples who look like traditional families, a man, a woman, and children. Maybe all the children are by that relationship, but they're not married. So those are, and that's a pretty common modern phenomenon. Interestingly, I'm told by friends in Europe that that's a very common way that many people decide not to marry these days because getting untangled is difficult. So they just choose to live as domestic partners with their children, and they never marry. Then we have same-sex couples, some of whom are married and some of whom are not married. And some of them have children. Some of them have conceived children in relatively interesting ways. Some of them have adopted children. So all of those things are something that needs to be taken into consideration planning for what I'm calling modern families. One of the issues that we have is that the law in Texas and elsewhere presumes that a family is a traditional family. So husband, wife, children, all by that marriage. And as a result, the defaults under the law will favor those kinds of families. So that can pose a real problem if your family doesn't fit in that mold. So for example, when I first started practicing law, and for many years afterwards, I think the first 20 years that I practiced law, Texas law said, if you die without a will, your assets, your community property goes to your children and not to your spouse. And that's really antithetical to what most people would think would happen. The law still says if you die without a will, your assets go to your children unless your children are the product of all your children have the same parent, and that parent is your surviving spouse. So we still have some pretty significant issues. If you die without a will, your assets probably, or maybe not likely to pass the way you'd want them to, or the way you think they would. They don't pass to the surviving spouse if you have even one child that's not a child of that relationship. So that's something to keep in mind. Similarly, and we'll talk a lot more about this later, similarly, there are rules in the Texas code that say what happens if you are in an accident and you become disabled. You need decisions made for you. The law presumes that the person you would want to make those decisions would be your spouse. But what if you're not married? What if we're talking about a longtime domestic partner couple that has never married? And so then it's going to presume different people have the rights to make those decisions for you, people that you may not have that much connection with. Maybe it's siblings, maybe it's your adult children, and maybe that would be okay, but it's not necessarily okay for that to happen, especially if you have a domestic partner that you've lived with for many years. So those are the kinds of things that make it really essential for non-traditional families to make sure they have every document, every estate planning document that they might need, and that they look at them frequently to make sure they still do what they want. So I would say initially we'd be talking about making sure you have a will that names the person that you would want to be your executor. And again, if you're not married and you have a domestic partner, you certainly want to give some thought to, is that the person that you'd want to handle your assets? You also, of course, want to make sure that you're covering whether you're children receive assets, or are they the children of the first marriage, the children of this marriage? Your spouse's children, do they get any assets if they're not adopted, and so on. So it's a much more complicated problem of disposing of your assets at your death. Normally, what I see is that people are most willing to use what are called marital trusts. They pass, or their domestic partner, but to use during his or her lifetime, and then at the death of that person, whether it's a spouse or whether it's a domestic partner, then those assets pass on to the kids, grandkids, whoever you want to have them. So that's important to make sure that you thought through how, if something happens to me, how does this person that I've lived with for many, many years and shared my life with, how does that person continue? Because they don't, for example, have the right to select my Social Security benefits. If I'm not married to this person, they even though my benefits may be the ones that are a lot larger, they wouldn't have the opportunity to get those larger Social Security benefits. And we'll talk a little bit also about retirement type assets, making sure that you've updated those beneficiary designations. Now, relationships, if you're married in Texas, whether you're same sex or you're more traditional looking family, you know that we also have community property that's kind of imposed on top of all the other issues we have. And so if you're married in Texas, anything you acquire during marriage, except by gift or inheritance, is community property. So if you, let's say, came into a marriage with some assets, and your spouse came into a marriage with some assets, and especially if it's a second marriage and you've got children by prior marriages, the one thing that I would definitely encourage you to do is have a marital property agreement. And under that agreement, you can, in Texas, under Texas law, you can agree these assets were the ones that I brought into the marriage, and I want those to remain as separate property assets. These are the ones that we're acquiring during our marriage, and we agree that either they're community or they're owned half and half, or I'm going to own what I earn and you're going to own what you earn. It's very flexible, but it's very important to get those kinds of issues ironed out prior to the death of one of the spouses, because again, let's say I come into a marriage after the death of my husband. So I have assets, I bring them into the second marriage, but I'm not careful. If I'm not careful about keeping all those things in accounts that are called separate property, and I'm not careful about moving the income from those separate property accounts into a joint account, then I've done what's called commingling. I've mushed those assets together, and Texas law presumes that once you've mushed them together, they're community. So they can lose the character they had when you came into the marriage if you're not careful. You can always undo that by a marital property agreement, and I would urge people to consider that, even if you didn't have a prenup. If you can have a marital property agreement later in your marriage, just defining what's mine is mine, what's yours is yours, what's ours is ours. And it makes it so much easier when something happens to one of the spouses. And people often say to me, oh, well, my kids are not going to get involved in this. Well, you never know. And it doesn't even have to be your children. It could be your in-laws. So it could be a son-in-law, a daughter-in-law who decides they want to get mixed up in your business once somebody has passed away. So it doesn't even have to be your kids. If they've got an interest because they were married to one of your children and they're thinking, well, this should have been separate property, and it should not go to the surviving spouse, that can breed some real issues. So, so I'd say be careful about how you hold your property, be careful about how it's titled, and be careful if there are issues like commingling, that you iron those out while the both of you are still around, as opposed to letting the kids and in-laws fight about them. So that's, I think, real important. The other thing is in many states around the country, people use what are called revocable trusts or living trusts instead of wills, or to take the place of their wills as the dispositive vehicle. Texas probate is so easy that Texans don't use revocable trusts that often. I see them used by elderly couples where they get to the point where they no longer want to manage their own assets. They want somebody else to be able to step in and manage assets for them, and so they set up these revocable. Another reason why you may want to set up a revocable management trust is that it is private. So the way you leave your assets, who you gave them to, what the shares were, and all those kinds of things becomes private. And nobody has a right to see that unless they're named as a beneficiary in that document. So that can be a big plus of having your plans, especially if it's it's a relationship that you don't necessarily want to be publicized, because wills by their nature are public. They get filed in the county courthouse, and anybody and everybody can go get a copy of them. Years and years ago, when Jackie Onassis died, I sent somebody from our New York office down to the courthouse to get a copy of her will. She actually had a will. She didn't have a revocable management trust. The reason I sent them down there is I had heard that she had left a big charitable leave trust, which she did. I just wanted to see it. I was curious to see how it was drafted and so on. And and apparently this associate of mine, I was at Fulbright and Jaworski at the time, and she in New York said she was in a long line to get a copy of Jackie O's will. That was just something lots of people wanted to see. Well, most of us, we're too boring. When our will is admitted to probate, nobody cares. But you could have people who are curious and looking, and it's kind of nice to set up a revocable management trust, put assets in there so that your will doesn't become public. You would have a will probably, but it would be really simple, and it would say, everything I haven't already put in my trust, I put in my trust. So none of the dispositive provisions are in there, and there's not a whole lot that's made public. So, high profile people tend to have revocable living trusts, which is why I was surprised that Jackie Onassis had a will, but I think she probably wanted people to know that she was doing this charitable stuff. So anyway, that's just a side point. So in addition to wills or revocable management trusts, which would spell out how you want property to pass at your death and to whom and who would manage it for you, you need a number of other documents as well. And I would say that everybody needs to look carefully at having some basic, what I'd call ancillary documents. Powers of attorney, for example. In Texas, we have something called a statutory durable power of attorney. So you would want to make sure that the person you would want in charge of your assets at the time you became disabled is listed on your statutory durable power of attorney, and list several alternates if you have people that you want to to serve, because that then allows, again, this domestic partner you're not married to, if they're not on your account, they can't get to your account to pay bills for you. So you need a power of attorney. If it's your spouse, then they have a lot of rights under the law to go to court and do so and so. But if you're not a married person, then this domestic partner really has no ability to even go to court and ask to be appointed in that instance. They would be well down the road, maybe not even on the list. So that's important. Another document, of course, that you want is a healthcare attorney, so that somebody can make medical decisions for you. People who've lived together for years and years, who, when their partner gets sick, has a stroke, is in a car wreck, they're not even allowed in the hospital room because they're not on the list. Under Texas law, there's nothing that gives them the right to be making decisions or even hearing about what's going on from a medical standpoint. We have this health privacy law called HIPAA that basically tells doctors and nurses and other healthcare professionals that they shouldn't be divulging your medical information to anybody without your permission. So there you have the information, not able to get it unless you've got a healthcare power of attorney, medical power of attorney, and what's called a HIPAA release. So often those are in the same documents, but they could be in separate documents. You could have a HIPAA release that lists a lot of people to get information. So maybe you'd want your kids to have information about your health care, but you don't want them making medical decisions for you. Then you could have a medical power of attorney that names your spouse or your domestic partner, but names the children as also able to get medical information concerning your condition, if you want that to happen. So that's an important document as well. You want to be sure in these non-traditional families, you want to make sure you also have something called a designation of guardian. You would, believe me, you would never want to have a guardian appointed for you, but there are instances where that's just simply going to happen. If you've got a regular power of attorney, usually people can operate under your financial, with your financial documents and so on, but every now and again you run into a situation where somebody actually needs a guardian. And so you want a designation of guardian that names the person, if it's your domestic partner, your same-sex spouse, whatever. You want to make sure that you've got those list of people that you want to be named your guardian if you ever need them. And there are two kinds of guardian. There's a guardian of your person, and that person is the one who makes decisions about where you live, what doctors you see, all of those kinds of issues you're having to do with
Marjorie, I think your internet connection is frozen for a moment. So we're going to see if it'll just stabilize for a second. It may be that you have to log out and log back on to join us. It looks like you're still frozen. She's logged out and she'll be right back. One moment, please. There she is.
Okay, are we back?
You're back.
Okay.
Great.
Oh, sorry.
That's
Somehow I died. So,
okay.
um,
I hope you had a will.
yes, I have a will. I have a will.
Okay,
Okay.
good.
Okay. So, I was talking about the fact that a lot of people want the same person to be, and again, the same person can be your executor, can be trustee of any trust your will creates, can be on your powers of attorney, can be on your designation of guardian. You just want to have all the documents that you need set up, or it could be different people. Um, uh, Another issue has to do with guardianship of your children. You want to address that, especially in a situation where, let's say you're a same-sex couple who has adopted a child. You want to make sure that the same-sex partner, if you're not married and that partner doesn't is not an adopted parent, want to make sure that they're named to be the guardian of the minor children. So if something happens to you, you've got minor children, you want to make sure who the guardian of those children would be. And again, putting several names in some sort of order makes sense to do that. So be sure and address that as well as guardianship for yourself. Guardianship for your minor children is very important. There's also a document called disposition of remains, and that document allows somebody to make funeral arrangements for you, provide for cremation, whatever you want. Don't put that kind of thing in your will. Put it in this separate document, the disposition of remains. I can't tell you how many times I've looked at wills drawn by other people and from many years ago, and they have all their funeral arrangements in their will. Well, guess what? You don't even look at the will until after the funeral. So then you have the family sitting around saying, "Oh, I wish we had known." I would have loved to have known this stuff, but we didn't know this because, often, as I say, the will doesn't get addressed until usually well after the funeral has happened and the interment or cremation or whatever has already happened. So all of those documents are very important. And just as important as wills are beneficiary designations. So beneficiary designations on your life insurance, make sure those are what you have in mind, and make sure to look at those often. And beneficiary designations on your retirement accounts are very important. Make sure those have been updated since your spouse died or your divorce or whatever. Make positive that those have been changed so that they now reflect what you have in mind. You might also want to consider setting up an account or two as joint accounts, joint tenants with right of survivorship or pay on death or something along those lines, where money would be available pretty immediately to pay for expenses, funeral, or if you're still alive, expenses that are required while you're in the hospital or something. Having a domestic partner on an account where you keep up maybe a month's worth or a couple months worth of expenses, money, so that they would have access to those assets to be able to pay bills for you and do whatever needed to be done. So all of those things I think make planning in a non-traditional situation a lot more important. The fact that same-sex couples can marry is so great because back in the day we had to jump through all kinds of hoops to try and figure out how to sort of come up with an equivalent, especially from a tax perspective, for non-married couples versus married couples. Right now, you know that the tax law, or you probably know that the tax law is extremely generous. You can give up to $11.8 million to whoever you want without any tax. So it takes a huge estate to actually be taxable. But having said that, even if Congress doesn't do anything, in 20 2026, January 20th amount. However, Congress may very well do something in the interim since we have such big deficits that we're running at this point. And it's always easier for Congress to get money from dead people than it is to get money from people who vote. I mean, I know some dead people vote, but not very many. So that's there's always an issue that the tax law could change, and it could again go down. The amount you can leave could go down to a point where it might make sense for you to do some planning. So plan number one is if there's no particular good reason not to marry, you might want to marry, because the tax law says anything you leave your spouse, whether you're Warren Buffett or whether you're me, anything you leave your spouse is tax exempt. So, and that's not going to change. So from that standpoint, that's the easiest planning decision you can make if there's not a good reason not to marry. And let me also address, while we're talking about reasons not to marry, you may want to enter into something called a cohabitation agreement with your domestic partner that says we're not married. We've lived together for many years, or we're planning to live together for many years, but we're not married, and we don't want any community property unless we actually go through a formal ceremony. We're not married. And the reason that you might want to do that is just to cut off any issues with respect to a possible claim of common law marriage. You may just want to say, look, we want to keep our assets separate. We're enjoying our life together, but we are not married, and we don't want to we're not holding ourselves out that way, and we don't want to be perceived that way from a legal standpoint. So that's another option if you are living very separate lives from a financial standpoint. You might want to have a cohabitation agreement that basically sets aside a common law marriage claim. That's often important when spouses are marrying or not marrying, but getting together late in life. They've gotten their assets all set up. They've got kids by prior marriage. They really don't want the entanglement of community property and all of those issues and so forth. So as I say, the tax law presumes that anything you give your spouse will be tax exempt. It does not then extend to anything you give a domestic partner. So, giving some serious thought to whether you want to be married is worth doing as well. So I'm happy to take questions.